Welcome back to the Emily Show. And if you say Emily, you sound a little different. Yes, it's a little bit of a cold, but we'll all be fine. So I know there will be comments. I figure we'll just address it at the beginning. Today we have a lot to talk about. Diddy doesn't want to be in jail anymore. Shocking, really. I mean, at this point, I feel like every show just needs a segment. Maybe I need a soundbite. We just need a segment of like, what's Diddy doing now? Because the amount of legal filings in this case is substantial. And this is just the criminal case today. We don't even have time to check in with the 20 plus civil cases at the moment, because Kouri Richins also would like to not be in custody. And is the Commonwealth in the Karen Read case starting to go after the media? We need to talk about one of their latest filings, of which there are many. Karen Read is back in the Superior Court Wednesday, November 13th. Kouri Richins was just in court on November 12th. And we have some other important dates to talk about and some exciting updates for this show and content in 2025. And today feels like a good day to talk about it because this week is the anniversary of the podcast, and we need to talk about that too. We should just get into it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to our sponsor, Thrive Causemetics. Right now, you can pick up my favorite Thrive product, which is, you know it, the Brilliant Eye Brighteners. I have not used eyeshadow since picking up the Brilliant Eye Brighteners a couple years ago because they make my eye routine easy. Whether it is day or night, or I'm finishing streaming and heading out to the Creed show, I can use the darker metallics to spice up my daytime look, or just use them as highlighter under my brows or in the corners of my eyes so you can see my eyes through my glasses. And what I love is, unlike other metallics, they are easy to get off at the end of the night, and I don't end up with them all over my face. I am not the best at makeup. Thrive makes it like crayons, and they use clean ingredients, no animal testing, and a portion of every purchase goes back to their Thrive giving partners. It's why cause is in the name. So if you are ready to check out their great holiday colors, including a black eye brightener to make that smoky eye dream come true, Thrive is luxury cosmetics that gives back. Head over to thrivecosmetics.com/Leonard for an exclusive 20% off your first order. That's Thrive Cosmetics, CAUSEMETICS.com/Leonard for 20% off your first order. Let's get back to today's episode. So yes, it is the anniversary of the podcast. And when I started this podcast 5 years ago under a different name with a different purpose, I never imagined that the journey would lead me here. And it really is because I started this as a podcast, at first audio only, talking about the law and shit. And my goal then, as I was still doing consulting work, was to really help people understand the concepts of law they might need as they run their creative businesses or their online businesses, even before they had the opportunity to sit down with the lawyer. So basic tenets of business and just basic tenets of law. But I always enjoyed sharing those lessons through stories and through lawsuits that I found interesting. And most of those touched on pop culture. Shocking, I know. And I started live streaming so that I could really talk back and forth with you in the real time chat. And I loved that real time interactivity to make sure that not only what I was saying was being conveyed and received, but also to answer questions I might not have even thought of. And as always, chat has jokes. So I love live streaming because chat is not only bae, but chat as a community, the Law Nerds are incredibly witty, very funny, make connections to things that I don't always make connections faster than I do. And as always, just brings an incredible amount of fun and support and really compassionate conversation around cases that are sometimes lighter and are sometimes heavier, but always conversations about the law and how it works. And our international law nerds bring such interesting perspective from watching really from the outside going, wait, what is going on? And then we watch cases together from around the country and talk about how a jury of 6 people works in one jurisdiction, how it has to be 12 in another jurisdiction. And today we'll talk about Kouri Richins, and her attorneys are arguing that it constitutionally should be 12, but it's not. And the Supreme Court has upheld that. But in Utah, it's 8, where they're saying that's not nearly enough. And I'm like, girl, in Florida, it's 6. So be happy with your 8. Take your 8 and go. But it's been really interesting not only to track how the law is implemented in different cases, but also how you are thinking about those cases. And we get to do that in real time. And I could never have imagined that, the broadcasting dreams that I didn't even dare to admit that I had really get to become a reality with not just the podcast, but now the YouTube channel, the podcast, the app, and everything that we've created over the last 5 years of the podcast and the last really 4+ years on YouTube. So taking the podcast into a live stream format to answer questions in more real time really paved the way for maybe this needs to be the full-time thing. And since late 2020, it has been the full-time thing. And we've built out Baker Media and this show and the YouTube channel and the app and the, merch store 2.0 in such an incredible way. The audio podcast has over 5 million downloads. The video episodes of the podcast have tens and tens of millions of views. And I never would have anticipated finding such an incredible community of folks that also want to talk about the nerdy law stuff, laugh at the stuff that happens in court that's unexpected, find judges across the country who we just absolutely stan, look at cases that we are surprised by and sometimes not surprised by, and really just keep talking about how all of it works together. And I'm just incredibly grateful and still surprised all the time that we get to do this. And that really leads me into what is the future of what was the Get Legit Law and Shit podcast, then became the Emily Show, and now is really a 2-day-a-week show because the episodes drop on Wednesday that are a bit more deep dive, and then the episodes that drop on Monday on YouTube are split to 2 different channels, but on the audio are all in one audio feed for you. So let me tell you what that looks like. But first, I'm going to take an opportunity to plug the Law Nerd app. We built it this year. It was one of our huge goals in 2024, and I'm super excited about it. And if you don't have it yet, lawnerdapp.com, because we have a ton of trials coming up in 2025, and you are going to want to stay in the loop. And since I have content placed on 2 different YouTube channels, if you are not also keeping in the loop with the audio feed on your favorite podcasting platform, the app will help keep you in the loop. Okay, plug done. Emily, what's happening? Well, remember how I said how much I love live streaming? Well, in 2025, I'm going to be doing more of that. So in 2025, the Wednesday episode is no longer going to be a Wednesday podcast episode. It is going to be a Wednesday live stream. So Tuesday, Wednesday, Thursday, we will be live. Of course, if we are covering trial or live court, there are always days that shift, but the intention is to take the live streams from 2 days a week to 3 days a week, and then keep the uploaded podcast as the Monday show, which has been Quick Bits that's now gotten quite longer. And the Monday show will be on the Quick Bits YouTube channel and will be here in the audio feed, plus the shorter versions, the curated versions, the EDB curated experience will be up on the Quick Bits YouTube channel and on the audio feed if you want to stay in the loop with the cases, but don't always have time for a live stream. And that will give me the flexibility to cover things more quickly. Oftentimes I record the podcast on a Monday, and by Wednesday we're adding addendums when it comes out. And sometimes these cases move that fast that I would just like to be live while I'm talking about it with you. So a big shift for me, but maybe not a big shift for you, especially those of you that are members that are used to recording with me behind the scenes. Don't worry, we'll be recording the Monday episodes behind the scenes. So that's just shifting which episode we record behind the scenes together. And as we go forward, it will give me, I hope, the opportunity to cover more stories in an overview on the Monday episode, and then keep our dives into the documents or into live court together on the podcast. And as I look forward to more trial coverage in 2025, It also gives the entire team some bandwidth around trial coverage and bringing you those clips and summaries of trial coverage, and not also putting out multiple additional uploads for different cases when we are in trial coverage, because this year that got a bit difficult for me to keep up with and for everyone on the team to keep up with, and really bringing you the type of coverage not only that you love, but also that I love doing. And I love this podcast, but I want to be live more. So the only way to do that for me really is to shift this to a live stream. And that's what we will be doing in the new year. So exciting things coming for 2025. After 5 years of this being the podcast on a Wednesday, it's shifting to the Monday episode, and we will be doing live streams 3 days a week. And I can't wait. Speaking of that, we should talk about what everybody else has going on for 2025. Will Diddy still be in custody? Will Kouri Richins get out of custody? And is the Commonwealth of Massachusetts going after the media? So let's get into the rest of the episode. And thank you so much for being on this journey. I appreciate you. You're like, Emily, you sound like you're about to be like, thank you for being here. Thank you for being a law nerd. Ta. I mean, yes and no. We're going to get into the rest of the episode. I really feel like at some point I'm going to just create an audio to be like, what did Diddy do now? Because every single week we are here saying literally, what did Diddy do now? Well, Diddy wants to get out of custody again. This motion was filed on November 8th by Sean Combs. We're going to go over it briefly because we also have some court orders we need to go over in the Diddy case. But it is another crack at getting released from custody. This is somewhat redacted because they are trying to argue that the circumstances of the offense have changed. You do not get to ask for bail to be reevaluated without a circumstance changing. When we talk about Kouri Richins asking for bail again, the change in circumstance there was at the original bail hearing, the prosecution still had the opportunity to seek the death penalty. And after the bail hearing, they had chosen not to seek the death penalty in that case. So a large change in circumstances, taking a case from a capital case to a non-capital case. Diddy has now asked for bail like 3 times, and he's appealed on it. And that appeal is on pause. Like an angry housewife, that appeal is on pause for the moment based on Diddy asking the Court of Appeal to hold the appeal until he made this additional motion. And then if this was denied, then to take the appeal off of pause and move forward. So the appeal is holding right now with regard to bail. And Diddy is in fact asking the third court to reconsider bail. Diddy says that he, through his counsel, renews his motion for release pending trial. This renewed motion is based on a significantly updated proposed bail package, new evidence, as well as changed circumstances. And we're going to go through their overview. First, he says Combs proposes an updated bail package that is far more robust than the previous proposal. I mean, the previous proposal were like armed guards and stay at the house and $50 million and on and on and on. They're negotiating against themselves at this point. I don't know what else they can add. It's like, well, if there's more that you can add, then why didn't you add it before? They say the proposed package even surpasses a bail package recently requested by the government in a comparable case in a neighboring district. So they looked at a case that the government was asking for, they say in a comparable case in another district in New York, and they're trying to mirror that. They say the updated proposed conditions include home detention with strict 24/7 security monitoring, which is somewhat what they had proposed before. And they said, and near total restrictions on Combs' ability to contact individuals other than counsel. Well, they tried to do that with Sam Bankman-Fried as well, and that didn't go so well, did it? They say that those conditions, quote, will reasonably assure the appearance of Mr. Combs as required and the safety of any other person and the community. Remember, before, the judges were concerned about the safety of the community, his contact with witnesses, etc. Plus, I don't think they are unafraid of his flight. The fact is that Diddy has enough money and access that even if it's not his private jet, are we to assume that Diddy couldn't find his way out of the United States if he really wanted to? It goes on to say, second, new evidence received in discovery from the government undermines the primary basis on which the government initially sought and Judge Carter ordered detention. The evidence makes clear that the government's case is thin. A bold argument. It confirms the defense's initial description of the events depicted in the March 2016 video recording. Quote, the video is not evidence of a coerced, quote unquote, freak off, but rather a minutes-long glimpse into a complex but decades-long consensual relationship between Mr. Combs and victim one. The defense has been arguing this from the beginning, that this relationship is consensual with him and Cassie, and that relationship is not evidence of trafficking. But I don't think it downplays what is in the video from the Intercontinental, but they continue to argue that the relationship with Cassie was a consensual relationship. That doesn't mean that there wasn't coercion there. Anyway, we're going to continue on with their arguments. I'm not here to rebut their arguments. That is the government's job. It says, additionally, the new evidence refutes the government's proffer at the initial hearing regarding a potential second alleged victim, and the new evidence confirms that the government's obstruction and witness tampering allegations at the initial bail hearing lacked a factual basis. So they're saying what the government argued at the initial bail hearing, and I broke all of that down for you. I was at that bail hearing. That episode of the show will be linked. But the government was arguing that this was an ongoing pattern. That's what we've seen in the civil lawsuits, but that's not what the defense is contending. They go on to say that Combs' current conditions of confinement infringe his constitutional right to participate in his defense. This is an argument that was made in Kouri Richins' bail hearing as well, in bail motions, that counsel doesn't have adequate access to their client to prepare for trial, and they need their client to have less restrictions so that they can prepare for trial. They say, given the government's amended estimate of the amount of discovery in this case and its unique format, including voluminous video and photographic evidence, Combs' release on the proposed conditions is necessary so he can review the discovery and prepare for trial. Defense attorneys have argued this in many courts across the country. At this point, does not seem persuasive to judges. It's like, yeah, well, defendants do have a right to prepare their defense. Custodial facilities make available a defendant to their defense attorneys in a way that is safe for the parties involved. And that's the end of it. That is one of the difficult things about being incarcerated, of which there are many. I wonder if the court is going to find that there's not a substantial change in circumstance and be like, there's not a change in circumstance, we're not rehearing the bail motion, because that's the first hurdle the defense is going to have to cross here. But what we're going to look at specifically is what they are saying is the new factual information. But before we get there, I do want to take a look at real quick some of these updated conditions. They offered that Combs will have no access to telephones or the internet except for during calls with counsel, which will be arranged by security personnel. He's basically trying to set up a private prison at his own home. Restrict all visitors except for counsel and pre-approved list, only consisting of specific family members. Again, they tried that with Sam Bankman-Fried. He had very limited access, and he still put one of the key government witnesses' personal diaries out to a reporter from the New York Times. So I don't know how persuasive this will be, and that's why the government keeps mentioning the SBF case. But it said that they will restrict all visitors except for counsel and a pre-approved list consisting of specific family members, and that will be with the consent of pretrial services. That Combs will avoid all contact, directly or indirectly, with any person who is or may be a victim or witness in the investigation, will consent to provide pretrial services random access to his residence. Generally, there are Fourth Amendment conditions on probation, and sometimes there can be on release, but pretrial services, like Miami, though. Not that the feds don't have offices in Miami. And they also continued on the list of people that have surrendered their passports, and they're still going to continue to sell the airplane and the rest of it. They go on to say over the past 6 weeks, the defense has received approximately 23.5 terabytes of discovery material, and that the material reveals new information about the case, the evidence, and the government's previous bail contentions that was, quote, not known to the movement at the time of the previous hearing. The new material, they say, demonstrates that the government's previously misrepresented the weight of the evidence. The court only has to find clear and convincing for bail. So the weight of the evidence is a bail consideration. However, these charges are also presumptive no bail charges. So it makes it very difficult for Combs or any defendant facing these charges to overcome that presumption and obtain bail. So then they get into all of the redacted. They say communications with redacted corroborate the defense. As noted, the government's allegations of sex trafficking relate to one woman referred to in the indictment as alleged victim 1, with whom Combs shared an 11-year relationship. And then they go through all of the discovery materials, which are redacted, and they say that the first mention of any sex trafficking or unwanted sexual contact involved alleged victim 1 was in November of 2023, 5 years after the couple's breakup. The evidence shows these allegations were merely attempts to obtain financial windfall from Combs. These are the same arguments they made previously, that the victim tried to sell a book, that the victim tried to obtain what they said in their oral arguments was a $30 million payday, that the victim has all these reasons to make things up, and that she is not characterizing their relationship the way that it was. The defense has characterized that as consensual, and we know that the defense has made these arguments before. They said that after her efforts to sell the book to Combs so it would never hit shelves failed, in the fall of 2023, they say the victim pursued a different strategy, the Adult Survivors Act, which suspended the traditional statute of limitations for sexual assault claims and was scheduled to expire on November 24th, 2023. They say in November, victim 1 indicated in discussions between her lawyer and Mr. Combs' lawyer for the very first time 5 years after their relationship ended that she had been sexually abused by Combs, again demanding $30 million. Again, these are all the same arguments they have made, and the defense has cried unfair in court pleading after court pleading, saying that everyone coming forward saying things about Combs is looking for a payday. Everyone coming forward, they say, is, making it hard for Combs to have a fair trial. And in filing after filing after filing, they continue to go after victim 1 and to go after the things that she had said, their argument of what their supposed motivation is, and on. They go on to say that with the release of the civil complaint, it's clear that the government just recycled victim 1's allegations. There is nothing new in that entire section. They then, in their motion, go on for pages saying that Mr. Combs has never run from a problem. He's not going to run. It talks about literally from the day he was born forward, and they have done this in every single motion. I don't know how well taken it will be with the court because, again, it is nothing new. And at the end, they conclude with, to ensure a fair trial, to protect Mr. Combs' constitutional rights, the court should order a release on the proposed conditions, which, again, are largely similar to the previous proposed conditions. The defense can continue to say, Your Honor, look, it's more. But wait, there's more. More is just, well, we won't let him be on the phone with anyone. I don't see a change in circumstance. I don't see a change in condition. The arguments they're making here are almost entirely, I think it's most fair to say, largely the same arguments they've made before. We will see what the court decides to do. I think it is very unlikely that Sean Combs will be out on bail anytime soon. Thank you to our sponsor of today's episode, Honeylove. With Honeylove, you know that you are going to be comfortable, whether it's breaking out your favorite winter sweaters or getting ready for the holiday dresses. Either way, you are going to be handled. Or if you're me, just putting on your fancier t-shirt and, a pair of real pants. But the great thing about Honeylove is with their incredibly comfortable bras, you don't have to worry about the back bulge, which is something I always worry about when I am wearing particularly my favorite soft and cozy sweaters, because they are a bit more fitted and I like to feel cute. But cute is never going to come before comfort, and with Honeylove, you don't have to pick. So whether you are looking for a better bra with no underwire, shapewear, or your new favorite set of pajamas, Honeylove has you covered, and I've got you covered with a deal. It's time to treat yourself to the best bras and shapewear on the market and sleepwear, and save up to 50% site-wide at honeylove.com/lawnerd for this month only at honeylove.com/lawnerd. It really is time to treat yourself. Inventory is limited and this sale ends soon, so make sure you head over there now. Elevate your style, elevate your comfort. Thanks to Honeylove. Let's get back to today's episode. You know who else wanted to be out on bail? Kouri Richins. Kouri Richins is the Utah woman who is accused of murdering her husband with a well over a fatal dose of fentanyl, poisoned him. Though we've heard now different versions of what that was in, I don't know if it's entirely relevant. The first version we heard of this was in a Moscow mule. She is also accused of the attempted murder of her husband about 2 weeks before on Valentine's Day in a breakfast sandwich. We watched the preliminary hearing on that case together. It's set to go to trial over about 3 weeks in the beginning of May 2025. It's been a very interesting case. They had a lengthy court hearing on November 12th, including a defense motion for bail. The court did find that there was a change of circumstances because the state is not seeking to make this a capital case. They are just seeking the 25 to life that this case carries. And as the court pointed out more than once, it actually carries 2 terms of 25 to life because of the attempted murder and then the murder. So there are actually 2 terms that could be stacked. So it could be 50 years to life or just a life sentence. We know that the courts in Utah don't set necessarily a fixed sentence, that is done later by the Department of Corrections. I covered that a bit more when we talked about the Ruby Franke case. But Kouri Richins' attorneys argued largely the same thing about access to their client that Sean Combs' lawyers argued, that to prepare this case where there are terabytes of data and there's video and there's photos and there's letters, we need to be able to go over that with our client. And the defense attorney made what I found to be the most compelling argument as a woman in my later 40s, is she said, Your Honor, I have to sit in the jail conference room across from glass on a tiny metal stool for hours trying to prep this with my defendant. And I was like, girl, I feel that. Yes, it would not be easy for the defense attorney. No, it would not be easy for the defendant to try to prep across glass and not be able to hand documents back and forth. But that is also the reality of being in custody. At the end of that hearing with regard to bail, the court was not persuaded. Kouri Richins will not be granted bail, will not be out on bail, and will not be allowed out of custody. And the court said, yes, the circumstance had changed. It's appropriate to hear a bail hearing. But the court found that Kouri Richins needed to be in custody for the safety of the community. And the court noted that her relationship with her children already is strained. Her children have been placed with the father's family, and there is very, very limited communication, the court indicated, with her and her children, and that would continue. I wonder if the court is concerned after the bail hearing, which I also covered, that Kouri had attacked her sister-in-law physically when her sister-in-law said, no, I'm the executor of the estate, the house, the safe, all of it. You can't access the things you're trying to access. And Kouri physically attacked her sister-in-law. I wonder how heavy that testimony still weighs on the court's mind, that if she's allowed out and wants to see her kids, her in-laws have every right to tell her no because they have custody of the children, and also what a difficult place that puts the children in. I will be covering more about that hearing soon because I want to go over the Commonwealth's motion in the Karen Read case, trying to go after some of the media, or at least their notes and their interview. When I talk about talking to the media not being a good idea for somebody pending a retrial, this is why. Karen Read has done numerous media interviews, including the Vanity Fair interview that I went over on live stream. I will again link it. If you're interested in my multi-hour, supposed to be a short stream that wasn't a short stream of me going through the entire Vanity Fair interview that was done with Karen Read. But this is not regarding the Vanity Fair interview. This is the Commonwealth seeking information from a Boston Magazine interview with Gretchen Voss. And there has been a fleet of motions filed recently in the Karen Read case. I will be going over those more on stream. Otherwise, today is going to be a 4-hour podcast and we're going to do it on stream together. But I wanted to go over this particular motion to see what the Commonwealth is trying to get to, and to again talk about the fact that doing interviews in the media like this, especially with a trial pending, is often not a good idea. But the Commonwealth has also filed notice that they're going to try to reconstruct the digital parts of the Lexus that they took apart and retest them. The defense is objecting to all of that. The Commonwealth is going after Karen Reed's father's cell phone and has tried to get a subpoena for both his cell phone and to Verizon regarding his phone account. I wonder how much that's connected to the Vanity Fair article where Karen Reed talks about the fact that it was actually her father searching for information regarding David Yannetti and finding a defense attorney, though that search from her father can't come in at trial anyway. So I don't know what relevant and searchable evidence else the Commonwealth is looking for, because that's not enough. We also saw a motion from the defense to try to release the sidebars because all of the sidebars from the first trial are impounded. That is Massachusetts' way of saying they are sealed for the moment. They have impounded them. But a number of you have asked me on stream, like more than a small number of you, when are we going to go over all the sidebars from the Karen Reed trial? Well, we're not, because they're impounded. The court has sealed them all. And the defense is asking the court to release the sidebars. And just from a curiosity standpoint, like, yeah, release the sidebars. Why are they sealed? What can we not know? But anyway, back to the motion at hand. The Commonwealth's renewed motion for all audio recordings, which means there's a previous motion. This is from November 6, 2024. For all audio recordings, interview notes, emails, text messages, voicemails in the possession of Gretchen Voss and or MetroCorp. Trying to drag the media into trial is probably not going to go well, but I'm interested to see how they think they're entitled to this, because we've seen these motions fail in other cases time and time again, including, the government trying to get to all of the unaired Real Housewives of Salt Lake City footage with regard to Jen Shah, though they were able to get some footage with regard to Tom Girardi. They say that the Commonwealth respectfully requests the court to order Gretchen Voss and keeper of records at Boston Magazine to produce the criminal clerk's office of the Norfolk County Superior Court the following: the complete audio record of all interviews between Gretchen Voss and the defendant, including but not limited to June 20th, 2023 and July 13th, 2023. Footnote: to the best of the Commonwealth's knowledge, Voss engaged in 2 audio recorded interviews with the defendant on June 20th, 2023 and July 13th, 2023. All handwritten notes of any conversation between Voss and the defendant, including but not limited to the, quote, off-the-record interview of the defendant. There's another footnote. Notes are going to be hard to get to. Footnote 2. An unrecorded interview has been referred to as the, quote-unquote, third interview between Voss and the defendant. All emails between the defendant and Gretchen Voss and or Boston Magazine, all text messages between defendant and Voss or Boston Magazine, all voicemail messages between defendant and Voss and or Boston Magazine. The sought information is evidentiary and relevant, cannot be obtained reasonably in advance of trial without this court order, and is being done so as to not unreasonably delay the trial. Lastly, the application is being made in good faith and not a fishing expedition. Well, I'm glad it was put out there first. I want to know what they think they're going to find. Argument: the court previously found that all materials sought by the Commonwealth meet the requirements of Rule 17a2. However, the court also attempted to balance the public interest in every person's evidence and the public interest in protecting the free flow of information to journalists. To that end, the court ordered only that the information that was on the record should be provided. The court did state that if, after reviewing the redacted on-the-record interviews, the Commonwealth believes it is entitled to further information, it is not precluded from reassessing its motion to the court. Well, there it is, Emily. Keep reading. The Commonwealth now respectfully requests that this court reconsider its prior order and provide all the sought-after information. In support of these requests, the Commonwealth states the following: the defendant has made tactical and repeated admissions outside of court regarding her activities during the evening of January 28th and early morning of January 29th. The defendant's statements to Voss are not protected by any privilege, and there is no legal basis to limit the Commonwealth's entitlement to all the defendant's statements to Voss. The defendant engaged in 2 recorded interviews. The first recorded interview on June 20th. The Commonwealth was provided a 3-hour and 19-minute recording of this interview. The second interview occurred on July 23rd, and the Commonwealth was provided a 14-minute recording for this interview. Footnote 3. During a January 18th hearing, counsel for Boston Magazine informed the court that the June 2023 interview lasted approximately 4 hours, and the July 23 interview lasted approximately 2 hours. So the prosecution is saying that they received a substantially redacted interview. The July 13th audio was marred by approximately 100 redactions, Many of the redactions occurred during discussion and admissions pertaining to critical issues in the case. Many of the redactions included interjection by the defense attorneys. The defense attorneys are allowed to interject when she's being interviewed. Oftentimes, when the recording resumes after redaction, the recording has diverted or redirected to a different topic from the one that was interrupted. Thank you to today's sponsor and host of the Law Nerd Shop, Shopify. Look, I've been telling you for a couple of weeks that the Law Nerd Shop 1.0 is going away, and we are rolling out Law Nerd Shop 2.0 with many of our legacy designs going away into the vault and new, fresh designs coming to you. But all of it is still powered by Shopify. Shopify has made it incredibly easy to take our shop to the next level, and I can't wait for you to see what we've changed. But with Shopify, we've been able to build out an entirely new shop. And for you, it is going to be a seamless experience because no one does selling better than Shopify. They are home to the #1 checkout on the planet, and you know we weren't going to change from using that. Plus, you can use Shop Pay, which boosts conversions over 50%. So whether you're just starting or you're taking your business to the next level like I am, Shopify is the e-commerce platform that's ready at whatever stage you are. It's no wonder that businesses that sell more sell on Shopify. And if you're ready to check it out for yourself, now is the time. Upgrade your business and get the same checkout that the Law Nerd Shop uses with their $1 per month trial period at shopify.com/lawnerd. Remember, this one's all lowercase. So go to shopify.com/lawnerd and upgrade your selling today and start hearing this sound soon. Let's get back to today's episode. An example supporting relevance of redacted information and the Commonwealth's right to all the audio recordings, including statements of all participants in the redacted statements, is presented below. And it would be hard again for the defense to argue here that these are privileged or protected because they're not. It's an interview. So it's not protected in that way, but they're going to give us an example. They say the excerpts that follow are just a few of many examples demonstrating why the Commonwealth is entitled to both the defendant's complete statements and the statements of other participants in the interview. Right, like the attorneys. And that's not privileged because there are other people there. It's not the attorneys just talking to their client. It's the attorneys, their client, and a media reporter. In her June 20, 2023 interview with Voss, the defendant professed, "I drinking like I normally would. I tend to talk a lot when I'm out in these. And when people see the bar footage, I'm very much in the middle of a group. And Lisa's seen it too. This is at McCarthy's and at the second bar as well, that I tend to stop drinking. And, I'm very extroverted around people when I'm in that environment, but we weren't redacted." Mr. Yannetti, well, you. Answer, yeah, in my 20s, the defendant discusses medical issues. The redaction, they say, interrupts the defendant's admission on a critical issue, her drinking alcohol the night in question. When the redacted audio resumes, the discussion had shifted from consumption of alcohol to a medical issue. Further, in her July 20th interview, the defendant makes more admissions, they say, that's relative to the issue of alcohol consumption. Question, and is the level of intoxication pretty high here for everybody? Answer, it's happy. Question, yeah? Answer, it's question, because you'd had a lot to drink, right? Answer, I wouldn't say I'd had like a normal amount. Question, what's normal? I mean, for what we've seen in this area, I've got questions. What's normal? Answer, like a vodka tonic every 40 minutes, footnote 4. Question, okay, and so you're feeling like buzzed? And I'm not judging, I'm just trying to get a sense. Answer, yeah, buzzed. Footnote 4. The claim of a vodka tonic every 40 minutes is undermined by the video evidence from a bar named C.F. McCarthy's. Of course, that's not really a proper footnote unless they're going to try to argue. Well, we'll see what they try to argue about that. Like, why does that need to be footnoted? They say shortly after these admissions, the interview continues. Question, yeah, okay, so then Jen's trying to get you to go and you are insisting, I'm leaving with John. Redaction. Answer, yeah, I had water. I had sips of water at Waterfall. Yeah, but I hadn't had anything to drink before about 9:15 that night. Everyone I met up with that night had been drinking long before. Question, yeah. Answer, I went out, so I would assume their level of intoxication was higher than mine. It goes on to say the defendant's admission of drinking a vodka tonic every 40 minutes is followed by a redaction shortly thereafter. Immediately after the redaction, the resumed audio then demonstrates a non sequitur claiming to consume sips of water at the Waterfall. The post-redaction assertion that she drank sips of water at the Waterfall is contradicted by the defendant herself in her interview with 2020, where she claimed, Answer, I had probably about 4 and not 4 that I completed either. I didn't drink maybe more than a few sips at the waterfall. I mean, another attorney is going to argue that a few sips being referred to in the 2020 interview is referring to alcohol, where here she's talking about drinking water, and a few sips isn't necessarily to the same thing, but we'll see what Boston Magazine argues. Notably, the defendant's June 2023 version claiming to have consumed, quote, sips of water at the waterfall is also contradicted by evidence presented at the defendant's previous trial. Another example supporting the relevance of all of participants' statements is exemplified in the July 13th interview, where Voss again explores the issue of alcohol consumption. Voss refers to the bartender at the waterfall on the evening of the alleged collision and questions, "She said to me that we never served her." Answer, they didn't. Jackson, never said, never served her. Answer, I didn't drink there. Okay, redaction. So, okay, and this is a question coming from the interviewer. Then I need to go back. For some reason, I thought they had like your drinks by the time. Answer, I was at the bar before and they knew by the bills. Question, at the bar before? Answer, but I really didn't drink at the second bar. I just socialized, and this is the same girl. She's heavy. Was Karen Reed. Answer, yeah. And that's from the interviewer, Voss. Answer, there's only like 2 bartenders. That's the owner's daughter. Question, she's gruff. Ma'am. Answer, she testified before the grand jury that I didn't appear drunk. I was talking, I was fine. There was no arguing, and no, she didn't serve me. I never went to the bar. And then this is Voss. Yeah, okay, interesting. So I must have conflated the 2 places, redaction. Answer, okay, right, redaction. We were at both places for 90 minutes, so 90 minutes at the end of the night with no alcohol. That was Reed. Question, right, then redaction. Answer, I told her that we were, redaction. Question, yeah. Answer, she said 3. Did you hear her say that? To be found by the 15th? So that's the last statement from Reed, but the redactions do make it difficult to understand what she's saying just from reading this. The Commonwealth goes on to say, without the full unredacted audio of the defendant and participant statements, the Commonwealth will be unfairly blocked from obtaining and providing the jury relevant evidence that places the defendant's admissions in full context. Are they going to try to call Gretchen Voss to the stand and be like, did the defendant tell you this? Because I think that's going to happen. I think they're going to zero in on, how do we know she was drinking? How do we know what she was drinking? Well, she's admitted it in multiple interviews. I think they're going to try to bring that in. The Commonwealth goes on to say there's no legal basis to preclude the Commonwealth from obtaining this relevant evidence. The defendant's statements are not hearsay and are instead substantive evidence admitted for its full force of proof. The other participant statements are interrelated to the defendant's statements for completeness and context. When a defendant assisted by her attorneys deliberately undertakes a public relations campaign, saturating the public with statements likely to reach the potential jury pool, they also run the risk that the statements may not be beneficial and be incriminatory. The helpfulness or unhelpfulness of the statements does not direct legal basis for disclosure. Further, all participant statements provide necessary context to the defendant's admissions. Statements made by the attorney in this context are afforded no legal protection. Moreover, it's likely the redacted portions include group discussions about the topics. It's likely impossible to fully parse the defendant's statements from other participants speaking in the group contained in the redactions. It goes on to say there is no recognized reporter privilege in Massachusetts, and it's well settled that, quote, news reporters do not have a constitutionally based testimonial privilege that other citizens do not have. So yeah, they're saying they can 100% be called to testify as to what Karen Reed told them. And then they go on and cite case law and analogize it to this case. I mean, at least nobody's arguing TikTok privilege in this case. And then the Commonwealth goes on to differentiate the situation when a source is confidential and the differences in protecting a confidential source vis-a-vis a source that is known is a defendant and whose statements are not hearsay. Remember, in trial, Karen Reed's statements being offered by the Commonwealth are statements offered against a party opponent. Her defense team can't introduce her own statements, but the Commonwealth can, and they are arguing that includes all statements she's made to the media, so they can call in the person she sat down with and said, did Karen Reed tell you this, that, and the other thing? And what, if anything, else? Except maybe now with the new prosecutor, Hank Brennan, we won't hear as many what, if any, things. So I'll just pose it to you. What, if any, questions do you have about what's going on in any of the cases that I've covered today? And what do you want more of a deep dive into? We have lots of motions in Karen Read to get into. There's like 5 motions in the Kouri Richins case to get into. And there's at least 2 different motions in the Diddy case that we have not deep dived yet. And I still owe you a music episode that I have been working on. And that might just, I keep saying a music stream. It might just have to be an episode here because cases have gotten very busy as people are trying to get stuff done in court ahead of the holidays, especially on those bail motions. So we will see what happens in the coming weeks, but hopefully courts will slow down a little bit, and they should in December as we get into the holiday season. Jurors don't want to be there over the holidays. The lawyers and the judges don't want to be there, and the defendants don't either. We're in the rush to get everything done before there's a bit of a lull between mid-December and mid to late January. So with that, thank you for being here. Thank you for being a law nerd. Thank you for making this podcast, what it is over the last 5 years. I love doing this, but what I do is not possible without this community. And I appreciate you so much. So for all of your support, all of the hours that you've listened and tuned in, all of the comments, all of the conversations we've had, truly thank you, because I get to do a thing that I love tremendously with all of you because all of you. So in the words of Dave Matthews, there is no this without you. So thank you and cheers. Dave's going to be like, that's not exactly what I said when I was doing my induction to the Rock and Roll Hall of Fame. It was, there is no Dave Matthews Band without the fans. And it's true. There is no Emily Show. There is no YouTube channel without the Law Nerds. So with that, thank you for being here. Thank you for being a Law Nerd. May your Wi-Fi be strong. May your family be well. May your toilet paper be plentiful. And may the odds be ever in your favor. I will talk to you soon in the next one. And in 2025, I will talk to you 3 days a week live. Let me know if you're excited, because I sure am. Cheers. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.